Today we're going to be going over part 2 of understanding the Foreign Investment in Real Property Tax Act, otherwise known as FIRPTA. We will discuss a requirement under federal law that a buyer withholds funds equal to 10 or 15% of the sales price of certain types of sales and send the amount withheld to the Internal Revenue Service at close of escrow. Federal law is called the Foreign Investment in Real Property Tax Act. This information is general in nature and does not intend to cover every fact situation. Slightly different facts may produce different results. Advising a client to consult a professional tax advisor to determine whether and how much withholding is required in a particular transaction is prudent. So today we'll go over a few things. We'll start with the sales contract. What provision should be made in the sales contract for compliance with FIRPTA? The deposit receipt or other sales agreement should reflect the agreement of the buyer and seller to comply with the requirements of FIRPTA by either having the proper amount of tax withheld and deducted by the buyer through escrow or obtaining/providing appropriate documentation that no withholding or reduced withholding is required. CAR's real estate purchase contract and receipt for a deposit, standard form RPA, covers compliance with FIRPTA under the paragraph entitled Withholding Taxes. Parties to transactions who use other contract forms should include an appropriate provision in each agreement. Residence of buyer. When does the exemption for residential property selling for no more than 300 apply? The exemption applies to any sale in which both of the following requirements are met. Total consideration, which is the sales price, is no more than $300,000, and on the date of the transfer, the buyer has definite plans to reside in the property for at least 50% of the number of days that the property is used by any person during each of the first 2 12-month periods following the date of transfer. Days that the property will be vacant are not taken into account for this purpose. The buyer is considered to reside in the property on any day the buyer, his or her brothers, sisters, ancestors, descendants, or spouse reside in it. CAR standard form AB may be used for this purpose. What if the buyer does not plan to reside in the property? Withholding will be required if the seller is a foreign person unless other exemptions apply. What if the buyer plans to reside in the property part of the time? Example, seller is a non-resident alien, a foreign person. Property is a single-family residence. Selling price is $225,000. Sale is scheduled to close September 1st, 2015. Buyer intends to use the property as a residence for 3 months between September 1st, 2015 and August 31st, 2016, and for 3 months between September 1st, 2016 and August 1st, 2017. Assuming none of the other exemptions apply, is the buyer required to withhold and deduct 15% or 10% if eligible percent of the sales price? Depends on what the buyer intends to do for the remainder of those 12-month periods. Suppose the buyer has definite plans that the property will be vacant for 9 months and used by the buyer as a residence for 3 months out of each of those 12-month periods. Based on those plans, the buyer will be using the property as a residence for at least 50% of the number of days the property will be in use during each of the 12-month periods following close of escrow. As a result, no withholding will be required. However, suppose the buyer instead plans to use the property as a residence 3 months and has agreed to rent the property to a friend for the remaining 9 months out of each of those 2 12-month periods. In this case, the buyer does not plan to use the property for at least 50% of the number of days the property will be in use each of those 2 12-month periods. Accordingly, withholding will be required. It is the buyer's plans on the date of transfer, normally date close of escrow, that will govern. Handling of funds and reporting. When withholding is required, how should the funds be handled? Withholding should normally be accompanied by having the escrow agent, title company, escrow corporation, financial institution, etc., withhold the funds required. The funds collected will normally be sent to the IRS at close of escrow. While the law does not specify that the withholding must be done through escrow, this procedure eliminates the possibility that the buyer might withhold funds at close of escrow and then not send them to the IRS as required. Withholding and transmittal of funds will, of course, require agreement between the buyer and seller in the deposit receipt or other sales agreement or in the escrow instructions. When must the withheld funds be sent to the IRS? Withholding must be reported and paid to the IRS by the 20th day of close of escrow. However, the transmittal of funds should normally be made simultaneously with the close of escrow, as in the case of other disbursements of seller's proceeds. How are the withheld amounts reported and transmitted? They are reported and transmitted to the IRS on IRS forms 8288 and 8288A. IRS form 8288A will be stamped by the IRS to show receipt, and stamped copy will be returned to the seller. If there is more than one buyer, must each buyer withhold the amount required. It's only necessary that the total proper amount be withheld once. Multiple buyers will not increase the total amount to be withheld. For a multiple seller transaction, withholding will be required only on the interest attributable to the seller who is a foreign person. However, the reporting forms discussed previously must be filled or filed for each seller who is subject to the withholding if there are multiple sellers. Withholding certificate. What is a withholding certificate? It is a form issued by the IRS specifying that no withholding or reduced amount of withholding is necessary. A withholding certificate will normally be available when, for example, taxes are due, when seller's gain will be less than 10 or 15% of the sales price. A withholding certificate will also be available when the seller has made other arrangements with the IRS to ensure payment of taxes is due. How can the parties obtain a withholding certificate? Either the buyer or the seller may apply for a withholding certificate. Normally, however, it will be the seller's responsibility to obtain the withholding certificate and provide it to the buyer to avoid withholding. The agreement between the buyer and the seller should make it clear whose responsibility it is to obtain the withholding certificate, if applicable. The IRS will generally act on a withholding certificate request within 90 days after receipt of a completed request. Are there different categories of withholding certificate applications? Yes, there are 6 basic categories. This categorizing provides for specific information that is needed to process the applications. 6 categories are applications based on a claim that the transfer is entitled to non-recognition treatment or is exempt from tax. Applications based solely on a calculation of the transferor's maximum tax liability. Applications under special installment sale rules. Applications based on an agreement for the payment of tax with conforming security. Applications for blanket withholding certificates. Applications on any other basis. An application for a withholding certificate under categories 1, 2, and 3 must be submitted to the Director, Internal Revenue Service Center, Ogden Service Center, P.O. Box 409-101 in Utah. An application for withholding certificates under 4, 5, and 6 must be submitted to the Assistant Commissioner, Director Office of the Taxpayer Service and Compliance. Is there a particular form to be used when applying for the withholding certificate? For applications for withholding certificates under categories 1, 2, and 3 in question 40, IRS Form 8288B, application for the withholding certificate for dispositions by foreign persons of U.S. real property interests must be used. For applications for withholding certificates under 4, 5, and 6, no particular form is required. However, if a specific format must be followed, detailed regulations cover the contents of the application, which are too lengthy to list here. Parties should consult regulations, Regulation 515, withholding of tax and non-resident, alien, and foreign corporations or their tax advisor to avoid submitting an incomplete or incorrect application. Must a buyer withhold the required percent even if an application for withholding certificate has been filed but not yet acted on by the IRS? Yes and no. Delayed reporting and payment may apply if the application for withholding certificate was filed with the IRS on or before the date of the transfer of the property. Note that withholding must still be done, but that the amount withheld need not be reported and paid to the IRS or the FTB until the 20th day after the IRS rules on the application for a withholding certificate. This procedure should be followed only on the advice of legal counsel. Following the IRS ruling, the amount withheld should be dispersed according to the ruling. However, the disbursement of funds by real estate licensees and escrow agents must conform to the instructions of the principals in the transaction. Whenever funds are held after close of escrow pending IRS action on an application for withholding certificate, escrow instructions should specify in detail how the funds are to be handled so that little or no clarification by the parties will be required later after close. Terms used. What is U.S. real property interest? USRPI. A USRPI is either an interest in real property, generally land, unsevered natural products, improvements to land, and personal property associated with the use of real property, located in the United States or the Virgin Islands. For interests in other U.S. possessions and territories, parties should consult counsel. Or an interest such as corporate shares in a U.S. real property holding corporation, whether the corporation is foreign or domestic. An interest in real property solely as a creditor is not considered a USRPI. For example, the sale of an existing note and deed of trust is ordinarily not a sale of U.S. real property interest under FIRPTA and does not require withholding. A transfer of existing leasehold would be a transfer of a U.S. real property interest and does require withholding if the transaction involves a foreign person and none of the exemptions apply. What is a U.S. real property holding corporation? USRPHC. A USRPHC is a corporation that holds U.S. real property interests that equal or exceed 50% of the fair market value of all its U.S. and foreign real property, plus other assets that are used or held for in a trade or business. Foreclosure properties. Does FIRPTA require withholding by a buyer at a foreclosure sale or by a lender who accepts a deed in lieu of foreclosure? Yes, in some circumstances. The rules are too technical to summarize here. Parties should consult their own counsel for legal advice. Transferees through a foreclosure or deed in lieu of foreclosure may also have special reporting requirements. IRS tax forms and publications. Where can I obtain the IRS tax forms and publications referred to in this discussion? You can get the IRS tax forms and publications referred to in this legal article in several ways. Through the IRS's website, which is www.irs.gov. Click on Forms and Instructions, or by phone at 1-800-829-3666. Where can I find additional information to be obtained? Principals should consult their own tax advisor for advice in particular transactions. You can also ask the IRS for tax help at their website, irs.ustreas.gov, or by phone at 800-829-1040 for pre-recorded messages covering various topics. For further information, refer to IRS Publication 515, Withholding of Tax on Non-Resident Aliens and Foreign Entities, and IRS Publication 519, U.S. Tax Guide for Aliens. Thanks for viewing. We have more training videos in the Rise Realty office. Please check them out.